They're not just deciding a Louisiana map. They're deciding whether the last surviving engine of the Voting Rights Act is allowed to exist. And if that sounds dramatic, it's because the court itself made it dramatic. This case was supposed to be narrow, technical, procedural, a dispute about whether a redistricting map in Louisiana constituted a racial gerrymander. Instead, the justices reached past the question in front of them and pulled something much bigger onto the table. Whether Section 2 of the Voting Rights Act is even constitutional. That is not housekeeping. That is structural demolition. Here's what actually happened. After the 2020 census, Louisiana, like Alabama, drew congressional maps with only one majority Black opportunity district, despite demographic data supporting two. Civil rights groups sued under Section 2, the part of the Voting Rights Act that prohibits voting practices that dilute minority voting strength. In Alabama, the Supreme Court surprised many observers by upholding Section 2 and ordering a second opportunity district. But Louisiana complied with the lower court ruling and drew a second majority Black district. And that's when a group of white voters challenged the new map, arguing that creating a second Black opportunity district discriminated against them. Pause there. Because that's the inversion. A law designed to prevent racial vote dilution is now being framed as racial discrimination. The shield is being recast as the weapon. And instead of simply resolving that narrow dispute, the Supreme Court did something far more revealing. It ordered re-argument and explicitly asked whether Section 2 itself remains constitutional. That's not an accident. Courts do not casually invite parties to brief the legality of a cornerstone civil rights statute unless at least some justices are prepared to reconsider it. So the real question isn't what happens to Louisiana's map. The real question is whether the last meaningful enforcement mechanism of the Voting Rights Act survives. Remember what's already gone. In 2013, Shelby County v. Holder gutted Section 5. The pre-clearance regime that required certain states with histories of discrimination to obtain federal approval before changing voting laws. That was the first incision. Section 2 became the fallback, the last line of defense, the only remaining nationwide tool to challenge racially discriminatory maps after the fact. If Section 2 falls, there is no functional federal backstop left. And that changes everything, because without Section 2, state legislatures, particularly in states controlled by one party, would have far more freedom to redraw congressional maps without fear of federal intervention based on racial vote dilution. Estimates vary, but analysts suggest that between a dozen and potentially 24 congressional districts currently represented by Black members of Congress could become vulnerable to redraw. Think about what that means, not in theory. In math, congressional control often hinges on margins of fewer than 10 seats. Remove Section 2 constraints, and you create the legal space to restructure maps in ways that could shift the balance of power in the House for a decade. This is not about a line on a map. This is about who writes federal law. And timing matters. Because redistricting doesn't operate in a vacuum. States have filing deadlines, primary calendars, ballot certification rules. Some states lock in candidates early, others have flexibility. Legislatures can adjust deadlines. They control the mechanics, which means if the court strikes Section 2 this spring, certain states could move quickly, either in response to the ruling or even in anticipation of it. And here's the destabilizing possibility. Republican-controlled legislatures could begin redrawing maps before the opinion even drops, operating under the assumption that the court will invalidate or neuter Section 2. They could gamble on the direction of the ruling. If they're wrong, they face litigation. If they're right, they gain structural advantage. That's the incentive structure. Now ask yourself, why would the court broaden the case to examine Section 2's constitutionality unless at least some justices were open to weakening it? If the goal were simply to affirm existing precedent, there would be no need to escalate the legal question. Courts signal through the questions they choose to ask. And this question is seismic. Section 2 is rooted in Congress's enforcement power under the 15th Amendment, the amendment that prohibits racial discrimination in voting. Congress has explicit authority to enforce that amendment through appropriate legislation. If the court narrows that enforcement authority, it's not just revising statutory law, it's redefining the balance of power between Congress and the judiciary in the realm of voting rights. That's not procedural housekeeping, that's constitutional recalibration. And here's the deeper pattern. Over the past decade, we've watched a systematic contraction of federal voting protections. Shelby County dismantling preclearance, Rucho v. Common Cause declaring partisan gerrymandering non-justiciable in federal court. Now potentially Section 2 facing constitutional retrenchment. Each step removes a constraint. Each step increases state-level discretion. Each step shifts the burden of protection away from federal oversight and toward political actors who directly benefit from drawing their own maps. That's not random. That's structural. And structural changes are harder to reverse than election outcomes. If Section 2 is significantly weakened or struck down, Congress technically retains power to legislate. The Constitution's Elections Clause gives Congress authority to make or alter regulations governing federal elections. In theory, a future Congress could enact nationwide redistricting standards, ban partisan gerrymandering, impose uniform rules, reinstate a form of preclearance, even mandate proportional representation. In theory. But here's the tension. Legislation requires unified political control and the willingness to use it. And historically, reform efforts have aimed to restore what existed before, what was lost in Shelby County. That may no longer be sufficient because the legal landscape has shifted. The court's federalism doctrine has evolved. The appetite for aggressive congressional intervention has fluctuated. Simply recreating the past may not survive future judicial scrutiny. So the strategic question becomes larger. Is the objective restoration or transformation? If one side has demonstrated a willingness to use every constitutional lever available, executive authority, litigation strategy, state-level lawmaking, then the response cannot be nostalgia. It must be structural, but that assumes the damage occurs. And we are not yet at that final page. The ruling has not dropped, but the signs matter. The court's decision to expand the question matters. The trajectory of prior voting rights cases matters. The composition of the court matters. When multiple indicators point in the same direction, ignoring them is not optimism. It's avoidance. If Section 2 stands untouched, it will be because at least 5 justices were willing to reaffirm Congress's enforcement authority in full. If it falls or is hollowed out, it will signal something far more consequential, that federal judicial protection against racial vote dilution has effectively ended. And if that happens, the immediate headlines will focus on maps. But the long-term impact will be about power. Who draws it? Who keeps it? Who loses it? This is not a symbolic case. It is a stress test of whether the federal government retains the capacity and the judicial permission to police racial discrimination in the most fundamental democratic act, voting. When the opinion drops, the language will matter, the scope will matter, the reasoning will matter. Because embedded in that reasoning will be the court's answer to a question it chose to ask. How much authority does Congress really have left to protect the right to vote? If you care about the trajectory of American democracy, this is not background noise. This is a hinge moment. And when hinge moments arrive, the worst mistake is looking away. Stay focused, stay informed, because what happens next won't just redraw a map. It will redraw the boundaries of federal power itself. Subscribe for more videos like that and hit that like button and share your thoughts in comment section.